This year, the state of Kuwait celebrates the 50th anniversary of the birth of its momentous and exemplary constitution. Kuwait's constitution combines the positive aspects of both presidential and parliamentary forms of government. It is based on principles of democracy, on the sovereignty of the nation, freedom of the citizen, and on equality of all citizens in the eyes of the law.
It's slightly different this year around because one of the decrees His Highness has issued this year was the formation of the higher National Council for the elections. This council is a seven-member council that is formed from the judiciary. They're all judges, and they oversee the whole process. Previously, the judiciary were only involved in the vote counting process. Now they are involved in making sure that the person who comes to register has the right prerequisites to register. They also define all the functions that other line ministries like information or health or education have to undertake. So this year round, the judiciary is running the elections. This is what the difference is, and this was an attempt by His Highness to give even more transparency and democracy to the process, so that the executive branch of government, the government now, no longer has any involvement, of course it's involved, but we do not call the shots anymore. We are not allowed to nominate different schools or different press centers. Now we work under the auspices of the judiciary in running this election.
As the state of Kuwait's constitution celebrates its Golden Jubilee, it coincides with the country's healthy pace of development towards a better future. Now for the history behind Kuwait's constitution and its prominent democratic reform. As soon as Kuwait became independent on June 19, 1961, ending the January 23, 1899 agreement that was signed by the 7th ruler Sheikh Mbarak al-Sabah with Britain, the state's 11th ruler Abdullah Salim al-Sabah announced his desire to complete the establishment of government and constitutional bodies as soon as possible.
في هذا اليوم العظيم من تاريخ وطننا العزيز نستقبل الذكرى الأولى لعيد الكويت الوطني بقلوب ملؤها البهجة والحضور بما حقق الله لهذا الشعب من عزة وكرامة ونفوس كلها عزيزة بالسير ودمت في بناء هذا الوطن والعمل بالروح والثابت بما يحقق لأبنائه من رفعة ورفاهية وعدالة اجتماعية لجميع المواطنين.
On August 26, 1961, only 2 months after signing the Independence Treaty, Sheikh Abdullah Salim issued an Emiri decree on establishing a ruling system based on clear, strong foundations as a prelude for issuing a constitution. Sheikh Abdullah Salim ordered the formation of a committee of 11 people to establish the Constituent Assembly. On September 6, 1961, the Constituent Assembly members' election law was issued, dividing Kuwait into 10 electoral districts and stating that each district should elect 2 members. According to the law, candidates had to be at least 30 years old and able to read and write, and the Constituent Assembly was to expire after 1 year from the day the election results were announced, unless the Constitution said otherwise. The first elections, in which 20 people won seats in the Assembly, were held on September 30th of the same year. On the occasion of holding the Constituent Assembly's first session, Sheikh Abdullah Salim gave a speech in which he emphasized the importance of democracy in building a modern state. During its first session, the Assembly chose by acclamation Abdul Latif Thnayan Al Ghanim as its Speaker, and on March 3, 1962, it formed a committee that consisted of the late Father Amir, Sheikh Saad Al Abdullah Al Sabah, and Abdul Latif Al Ghanim, Yaqub Al Hmaydi, Mahmoud Al Khalid, and Saud Al Abd Al Razzaq to prepare a draft of the Constitution. After holding 23 sessions, the draft was ready, discussed, and approved by the Constituent Assembly, then was presented to Sheikh Abdullah Salim, who endorsed it on November 8, 1962, and issued it on November 11th. On January 15, 1963, the Constituent Assembly held its closing session, and late Emir Sheikh Jabir al-Ahmed al-Jabir al-Sabah, who was then acting Deputy Prime Minister, gave a speech stressing that the Assembly was successful in realizing the desire of the father of the Constitution, Sheikh Abdullah Salim. Only 7 days later, elections were held for the country's first National Assembly. The Constitution came into force on January 29, 1963, when the first session of the National Assembly of Kuwait convened. The Kuwaiti Constitution includes 183 articles divided into 5 parts. The first part of the Constitution is dedicated to the state and the system of governance, and it contains the first 6 articles. Naturally, Article 1 deals with sovereignty and territorial integrity and states that Kuwait is an independent, sovereign Arab state. Neither its sovereignty nor any part of its territory may be relinquished. The people of Kuwait are part of the Arab nation. To that extent, Article 2 states that the religion of the state is Islam, and that Islamic Sharia shall be a main source of legislation, and Article 3 asserts that the official language of the state of Kuwait is Arabic.
إن تعاليم ديننا الحنيف وقيمه السامية تحثنا على تجسيد فضيلة الأمانة والمحافظة على قيم الدين وحقوق الوطن وحمايتها من دواعي التفريط والإهمال والبعد عن مظاهر الهدر والإسراف. إن أهم معاني الأمانة أن يحرص الإنسان على أداء واجبه كاملا في العمل الذي يؤديه، وأن يسهر على حقوق الناس التي اؤتمن عليها. إن الحكمة تقتضي منا أن نراقب ونستوعب ما يدور في عالمنا من متغيرات وتطورات، فعلينا أن نستشعر مخاطر الأزمة الاقتصادية العالمية وانعكاساتها وآثارها السلبية على اقتصادنا الوطني، وأن نعمل جميعا يدا واحدة لإصلاح الخلل في وضعنا الاقتصادي.
Article 4 states that Kuwait is a hereditary emirate, the succession to which shall be in the descendants of the late Mubarak al-Sabah, and Article 5 dictates that the flag, emblem, badges, decorations, and national anthem of the state shall be specified by law. Finally, Article 6 deals with the democracy and maintains that the system of government in Kuwait shall be democratic, under which sovereignty resides in the people, the source of all powers. The second part of the Constitution deals with aspects of the fundamental constituents of the Kuwaiti society and includes the articles from 7 to 26. Articles 7 and 8 discuss the state goals and the guardian state, with the first stated justice, liberty, equality are the pillars of society, cooperation and mutual help are the firmest bonds between citizens, while the latter maintains that the state safeguards the pillars of society and ensures security, tranquility, and equal opportunities for citizens. Family is an extremely important part of Kuwaiti society, as family is the cornerstone of society, and so Article 9 aims to preserve the integrity of the family and strengthen and protect its ties, while Article 10 is specifically catered to protect the youth, and Article 11 ensures aids for citizen in old age, sickness, or inability to work. It also provides them with services of social security, social aid, and medical care. Article 12 deals with the safeguarding the Arab and Islamic heritage and contributing to the advancement of human civilization. Moving to education, which is also a strong and vital pillar of Kuwaiti society, it is touched upon in Article 13 in general, while Article 14 specifically targets the promotion of science and arts.
أخواني وأبنائي وبناتي، لقد أكدت في مناسبات عديدة على أن ثروة الوطن الحقيقية تكمن في شبابه، فهم عدته وعماده وأمله في بناء حاضره ومستقبله. لذا فإن علينا استثمار الطاقات البشرية والإبداعية الواعدة في شبابنا وصقل مواهبهم وتحفيزهم على العطاء والمشاركة في تنمية الوطن. ولن يتأتى ذلك إلا بتقويم وتطوير مؤسساتنا ومناهجنا التعليمية والرقي بنظامنا التعليمي ليتمشى مع متطلبات العصر. فبناء مستقبل الوطن لا بد أن يواكبه عملية بناء الإنسان الكويتي وإعداده، وعلى أبنائنا الطلبة والطالبات تسخير مواهبهم وتكريس طاقاتهم واستغلال أوقاتهم للنهل من العلم والتحصيل والتزود من معارف وعلوم العصر، وعليهم ألا يلتفتوا إلى ما يروج من دعوات تشغلهم وتبعدهم عن طلب العلم والتحصيل. إن عالم اليوم تتناوله الأهواء وتتجاذبه الآراء، خاصة في ظل ما نشهده من انفتاح وتطور إعلامي، وهو الأمر الذي يتوجب معه النصح والتوجيه لأبنائنا حتى يسلكوا الطريق الذي يكفل لهم الارتباط بوطنهم والتمسك بعقيدتهم. فالكويت اليوم أحوج ما تكون لأبنائها من أي وقت مضى.
Article 15 deals with health care, Article 16 to 18 with private and public property rights, and Article 19 with confiscation issues. Meanwhile, Article 20 deals with the national economy, Article 21 with natural resources, and Article 22 with employment and tenements. Finally, Article 23 to 26 deals with banking, taxation, state burdens, and public office, respectively. The third part of the Constitution is devoted to public rights and duties and includes Articles 27 to 49. Article 27 states that the law shall be defined and the Kuwaiti nationality. No deprivation or withdrawal of nationality may be effected except within the limits prescribed by law. Consequently, Article 28 deals with deportation and return, and Article 29 dictates that all people are equal in human dignity and in public rights and duties before the law, without distinction as to race, origin, language, or religion. Meanwhile, Article 30 deals with personal liberty. Article 31 discusses arrest, relocation, and the prohibition of torture. Article 32 with crime, and Article 33 with personal penalty. From then, Article 34 states that an accused person is presumed innocent until proven guilty in a legal trial at which the necessary guarantees for the exercise of the right of defense are secured. Article 35 to 37 deal with freedom of religion and belief, freedom of opinion and expression, and freedom of the press. Article 38 with trespassing homes, and Article 39 with freedom and secrecy of communication.
إذا كانت حرية القول والتعبير مكفولة للجميع فإن ذلك لا يعني استخدامها للمساس بوحدتنا الوطنية وبالثوابت التي تعارفنا عليها وسار عليها الآباء والأجداد. وإنني أدعو القائمين على كافة وسائل الإعلام المقروءة والمرئية والمسموعة أن يتقوا الله في وطنهم وأن يمارسوا دورهم الإعلامي بوعي ومسؤولية دون تضليل أو تهويل أو إساءة للوطن.
Article 40 maintains that education is a right for Kuwaitis that is guaranteed by the states in accordance with law and within the limits of public policy and morals. Articles 41 asserts that every Kuwaiti has the right to work and to choose the type of work. Simultaneously, Article 42 indicates that there shall be no forced labor except in the case specified by law from national emergency with just remuneration. Article 43 deals with the right to form an association, Article 44 with the right to hold private assemblies, Article 45 the right to petition, Article 46 with asylum, and Article 47 with national defense and military service. Finally, Article 48 refers to the taxation and minimum standard of living, while Article 49 calls for the observance of public order and morals. The fourth and largest section of the Kuwaiti Constitution focuses on the executive powers and includes Article 50 through 173. However, it is split up into 5 chapters. Chapter 1 deals with general provisions and regarding separation and the constitutionality of powers. Article 50 states that the system of government is based on the principle of separation of powers, functioning in cooperation with each other in accordance with the provisions of the Constitution. Article 51 asserts that the legislative power is vested in the Emir and the National Assembly in accordance with the Constitution, while Article 52 says the executive power is vested in the Emir, the Cabinet, and the ministers in the manner specified by the Constitution. With regards to judicial power, Article 53 says it is vested in the courts, which exercise it in the name of the Emir within the limits of the Constitution. On the other hand, Chapter 2 focuses on the head of state, whereby which Article 54 states that the Emir is the head of the state, and his person is immune and sacred. To that extent, Article 55 says that the Emir exercises his powers through his ministers, and Article 56 says that after the traditional consultations, the Emir appoints the Prime Minister and relieves him of office. The Emir also appoints ministers and relieves them of office upon the recommendation of the Prime Minister. The ministers are appointed from amongst the members of the National Assembly and from others, and finally, the number of ministers in all shall not exceed 1/3 of the number of members of the National Assembly. Article 57 discusses the new government, and Article 58 says the Prime Minister and the ministers are collectively responsible to the Emir for the general policy of the state. Every minister is also individually responsible to the Emir for the affairs of his ministry. Article 59 classifies the powers of the Emir specified by law. Article 60 states the oath of the Emir's office, and Article 61 says that in the event of his absence outside the country and the inability of the heir apparent to act as deputy for him, the emir shall appoint, by an emiri order, a deputy who shall exercise his powers during his absence. The said emiri order may include a specified arrangement for the exercise of the said powers on behalf of the emir, or a limitation of their scope. Subsequently, Article 62 specifies the qualification of the deputy emir. Article 63 states the oath of the deputy emir's office, and the Article 64 deals with the incompatibilities of the deputy emir. With regards to the promulgation of laws and the initiative of the emir, Article 65 claims that the emir has the right to initiate, sanction, and decree laws. Meanwhile, Article 66 says, reference of a bill of reconsideration is by a decree stating the grounds therefor. If the National Assembly confirms the bill by a 2/3 majority vote of its members, the emir sanctions and decrees the bill within 30 days from its submission to him. If the bill does not receive the said majority, it may not be considered during the same session. Article 67 states that the emir is the supreme commander of the armed forces, and regarding war, Article 68 says the emir may declare a defensive war by decree. Offensive war is prohibited. Meanwhile, Article 69 says the emir may proclaim martial law in the cases of necessity determined by law and in accordance with the procedure specified therein, and Article 70 says the emir concludes treaties by a decree and transmits them immediately to the National Assembly with the appropriate statement. Article 71 deals with the emergency decrees, Article 72 with the execution of laws, Article 73 with regulations, Article 74 with diplomacy, Article 75 with pardon and amnesty, Article 76 with orders of honor, Article 77 deals with minting coins, and Article 78 with the remuneration of the emir. Chapter 3 moves to the National Assembly and begins with Article 79, which states that no law may be declared unless it has been passed by the National Assembly and sanctioned by the emir. Article 80 deals with the election and ministerial members and says that the National Assembly is composed of 50 members elected directly by universal suffrage and secret ballot in accordance with the provisions prescribed by the electoral law. The Kuwaiti Parliament voted to give women the right to vote and to run for office on May 17, 2005. The motion passed with 35 votes for and 23 against for the first time in Kuwait's history. After Kuwaiti women were given the right to vote and run for office, they failed to win any seats in the 2006 and 2008 elections. However, in 2009, women won 4 seats in Kuwait's parliament, making it the first in the state's history to see women in elected government. A total of 16 women were among 210 candidates vying for the 50-seat assembly. His Highness the Emir Sheikh Sabah Al-Ahmed Al-Jaber Al-Sabah appointed the first Kuwaiti woman in 2005 to be the Minister of Planning and the Minister of State for Administrative Development. Currently, women in Kuwait are considered to be among the most emancipated women in the Gulf region. They are able to work freely as police officers, royal guards, special forces officers, and immigration officers, and can achieve positions of power and influence. On the other hand, regarding constituencies, Article 81 states that the law determines electoral constituencies. Kuwait was divided into 10 districts in the National Assembly elections between 1963 and 1975. Each district elected 5 deputies to the assembly. Before the 1981 elections, the government redistricted Kuwait, creating a system of 25 districts. Each of the 25 districts elected 2 members of the National Assembly, for a total of 50 elected members. Each voter could cast ballots for two candidates, though it was also possible to vote for only one candidate. In each district, the candidates who won the largest and second largest number of votes earned seats in the National Assembly. In 2006, the National Assembly passed legislation to divide Kuwait to 5 electoral districts only. The voter could cast votes for 4 candidates. In each district, the highest 10 candidates earned seats. It was hoped that this would make vote buying more difficult and decrease the importance of tribe, family, and sects in elections. However, recently an amended electoral law was published in the official Gazette, thus becoming effective. The Gazette published a decree of Law Number 20 of 2012, which amended Law Number 42 of 2006 regarding the number of votes each eligible voter could cast. The amendment specified that every voter has the right to elect only one candidate in each of the 5 constituencies, and contrary to the ballot paper, would be disqualified.
Our elections always there are very minimum doubt about its fairness, very minimum, because it's very transparency. It's also the government in the last election they involved other institutions, civil service institutions to observe the election, but we have no doubt about the fairness of the election, and we hope that this election also will follow the same.
The new law reduces the number of votes each voter can cast from 4 to 1 in order to protect national unity, enhance democratic practice, and achieve equal opportunities and fair representation of the society in the 50-seat parliament. Back to the Constitution, Article 82 deals with the qualifications of the members of the National Assembly, and Article 83 with terms and re-election, stating the National Assembly term is 4-year calendar years, commencing with the day of its first sitting. Elections for the new assembly take place within the 60 days preceding the expiry of the said term, due regard being given to the provisions of Article 107. Article 84 discusses National Assembly seat vacancies. Article 85, the annual ordinary session. Article 86, the start of the ordinary session. Article 87, the first session. Article 88, the extraordinary sessions. Article 89, the prorogation of sessions. Article 90, the place of the meeting. And Article 91 states the oath of the members. Article 92 says the National Assembly elects at its first sitting and for the duration of its term a president and a deputy president from amongst its members, and Article 93 states that within the first week of its annual session, the Assembly forms committees necessary for its functions. Article 94 deals with the publicity of the National Assembly sessions. Article 95, the validation of the election process. Article 96, with the resignation of members. Article 97, with quorum and majority. Article 98, with government programs. Article 99, with questioning the government. Article 100, with interpellations. Article 101, with the vote of no confidence. Article 102, with the no confidence in the Prime Minister. And Article 103, with the continuation of the government. Article 104 states that the Emir opens the annual session of the National Assembly, whereupon he delivers an Emiri speech reviewing the situation of the country and the important public matters which happened during the preceding year, and outlining the projects and reforms the government plans to undertake during the coming year. Hence, Article 105 deals with the response to the Emiri speech, and then Article 106 with adjournment of the National Assembly meetings, and Article 107 says that the Emir may dissolve the National Assembly by a decree in which the reasons for dissolution is indicated. However, dissolution of the Assembly may not be repeated for the same reasons. Article 108 says the members of the Assembly represent the whole nation. Article 109 discusses member bills. Article 110, indemnity. Article 111, immunity. Article 112, the Assembly discussions. Article 113, the Assembly requests. Article 114, the committees of inquiry. Article 115, petition committees. And Article 116, the governmental right to speak. Article 117 deals with standing orders and the deputy to presence. Article 118 with ordering the Assembly and no presence of forces. Article 119 with the remuneration of the President and the Deputy President of the National Assembly. Article 120 with incompatibilities of membership, and Article 121 with economic incompatibility. Finally, Article 122 states that the members of the National Assembly may not be awarded decorations during their mandate. Chapter 5 deals with the executive power, and Articles 123 says the Council of Ministers has control over the departments of the state, while Article 124 deals with the remuneration of the government, Article 125 with the qualifications of ministers, and Article 126 states the oath of the ministers. Meanwhile, Article 127 discusses the supervision by the Prime Minister, and Article 128, secrecy, quorum, majority, cooperation, and submission. Article 129 states that the resignation of the Prime Minister or his removal from office involves the resignation or removal of all other ministers, and Article 130 deals with the ministers and directives. Article 131 with the immunities of the ministers. Article 132 with the ministerial offenses and indictments, and Article 133 with self-government. Article 134 moves to establishing taxes, and it claims that no general tax may be established, amended, or abolished except by a law, while Article 135 deals with public funds and expenditure, Article 136 with public loans, Article 137 with loans of self-governing bodies, Article 138 with state properties, and Article 139 with the financial year. Article 140 discusses the state's annual budget, which should be drawn up by the government, comprising the revenue and expenditure of the state, and submits it to the National Assembly for examination and approval at least 2 months before the end of each current financial year. Furthermore, Article 141 deals with the budget discussion and its purpose, Article 142 with the specific funds, and Article 143 states that budget law may not include any provisions of establishing a tax. Article 144 says the budget shall be issued by a law, and Article 145 focuses on the continuing of the budget, Article 146 on the changes of the budget, Article 147 on maximum expenditure, Article 148 on general budgets, and Article 149 on final accounts. Meanwhile, Article 150 says the government must submit to the National Assembly a statement of the financial position of the state at least once during each ordinary session, and Article 151 deals with Audit Commission. Regarding the country's natural resources, Article 152 states that no concession for exploitation of either a natural resource or a public service may be granted except by law and for a limited period. Moving to the business aspects, Article 153 says no monopoly may be granted except by law and for a limited period, and Article 154 discusses currency, banking, and standards. Article 155 states that the law regulates salaries, pensions, compensation, subsidies, and gratuities, which are a charge on the state treasury, whereas Article 156 refers to the provisions of the local budgets. Concerning military affairs, Article 157 maintains that peace is the aim of the state and the safeguard of the integrity of the country, which is part of the integrity of the greater Arab world, is a trust devolving upon every citizen. Then Article 158 deals with the military service, Article 159 with the establishment of the armed forces, Article 160 with mobilization, and Article 161 with the Supreme Defense Council. Lastly, Chapter 6 focuses on judicial power, and Article 162 discusses the impartiality of judges. Articles 163, the independence of judiciary, Article 164, the court system and military courts, Article 165, the publicity of trials, and Article 166, recourse of the courts. Moreover, Article 167 deals with the public prosecution, Article 168 with the Supreme Judiciary Council, Article 169 with the administrative jurisdiction, Article 170 with legal departments, Article 171 with the councils of state, Article 172 with conflicts of jurisdiction, and Article 173 with constitutional review. The fifth, the final chapter of the Constitution, focuses on the general and transitional provisions and consists of 10 articles from 174 to 183. Concerning amendments to the Constitution, Article 174 maintains that the Emir, or one-third of the members of the National Assembly, have the right to propose a revision of the Constitution by amending or deleting one or more of its provisions or by adding new provisions. However, Article 175 specifies the limits to constitutional amendments, such as the provisions relating to the Emir system in Kuwait and the principles of liberty and equality provided for in this Constitution, which may not be proposed for revision except in relation to the title of the Emirate or to increase the guarantees of liberty and equality. Meanwhile, Article 176 deals with the powers of the Emir, Article 177 with the continuation of treaties, Article 178 with the publication of laws, Article 179 with retroactive laws, and Article 180 with the continuation of laws. Article 181 asserts that no provision of this Constitution may be suspended except when martial law is in force and within the limits specified by the law. Under no circumstances may the meetings of the National Assembly be suspended, nor shall the immunities of its members be interfered with which during such period. Article 182 refers to the publication of the enforcement of the Constitution, which shall be published in the official gazette and come into force on the date of the meeting of the National Assembly, which shall not be later than January 1963. The final article of Kuwait's Constitution reads, Law Number 1 of 1962 concerning the system of government during the period of transition continues to be in force, and the present members of the Constituent Assembly continue in the exercise of their duties specified in the said law until the meeting of the National Assembly. His Highness the Emir Sheikh Sabah Al-Ahmed Al-Jaber Al-Sabah signed Decree Number 23 for 2012, endorsing a deal on the settlement of the financial dispute between the government of the State of Kuwait and the government of the Republic of Iraq. The Emiri decree published in the official gazette was based on the presentation made by Deputy Prime Minister and Foreign Minister Sheikh Sabah Al-Khalid Al-Hamad Al-Sabah and Minister of Communications Salim Al-Udayna. It approves the pact reached by the two sides on July 18, 2012, to settle the financial dispute between Kuwait Airways Cooperation and Iraq Airways and stop litigations in this regard. The decree shows that the Kuwait Airways filed a number of lawsuits against Iraqi Airways, the government and the Ministry of Finance and the Ministry of Transport and other state institutions in Iraq, claiming damages from the Iraqi side. In an effort to promote closer ties, the two countries reached a 5-point deal on July 18, 2012, in the state of Kuwait. To become effective, the deal required an endorsement by an Emiri decree pursuant to second paragraph of Article 70 of the Kuwaiti Constitution. It is in the best interest of Kuwait in the current delicate state to set up the legislative and executive measures relating to the enforcement of the deal to meet its obligations. As Article 71 of the Constitution allows adoption of decrees with the force of law in case of the absence of the National Assembly, it was necessary for the political leadership to adopt the decree in question to avoid missing the ultimatum for the endorsement of the deal, which is about to elapse. The 5-point pact provides the Kuwaiti Ministry of Communication arranges the final statements of Kuwait Airways Company claims for damages from Iraqi Airways in a friendly way. The accord annuls the deal reached by the two sides on March 14, 2012, without leaving any legal impacts. Another draft law decree recently approved by the Kuwaiti cabinet was the establishment of a higher National Electoral Committee. It also made amendments on Law 35/1962 regarding the National Assembly elections. The first article of Draft Law Decree 21/2012 stipulated that the committee was tasked with supervising the electoral process in coordination with the concerned government and non-governmental entities. The committee is also in charge of putting a general plan for the electoral process and making sure all candidates meet the legal prerequisites. Although the committee, consisting of 9 judges, is tasked with making sure all parties involved in the electoral process to be neutral and abide by standards of transparency and integrity, especially during balloting and vote counting, as well as reporting any complaint or violation to the general prosecution. The draft law also stipulated that the committee has the right to form subcommittees to help it perform its duties, as well it can use the help of concerned NGOs to follow up on the electoral process. The commission will be formed for ensuring integrity, transparency, independence, and utmost impartiality of the elections. Moreover, its formation is designed to boost confidence in the electoral process in manner that would reflect the actual will of the voters. The relevant bill includes provisions that address shortcomings that have marked previous polls in terms of nomination, dates of tallies, outcome declaration, as well as ensuring that representatives of the candidates will be able to have access to all necessary papers when the tally begins. The law, consisting of the 7 articles, also specified an amount of 500 Kuwaiti dinar deposit for candidacy registration to be later redirected to charity upon directives of the Minister of Social Affairs and Labor should the candidate decide to pull out of the race nor did not receive 10 correct votes. Another issue that has cast a shadow over the country is the privatization of the national airlines. A bill has been adopted amending provisions of the Law No. 6 of 2008, stipulating transforming Kuwait Airways Cooperation into a shareholding company. On January 9, 2008, the National Assembly approved the plan to turn KAC into a private shareholding company. Kuwait Investment Authority formed the Foundation Committee for the privatization of the company, which started the work immediately after signing the decision. However, the most serious challenge facing the committee was transferring the employees who do not work for KAC once it becomes a shareholding company.
Well, of course, thankfully, all the elections, at least in the last 20 years since the invasion, have been fair and transparent. There have been very few negative voices. Thankfully, the last election in 2012 was attended by separate NGOs, some European, some Arabic NGOs, and they stated very clearly how fair and transparent this election was. We hope to maintain the standard. The Ministry of Interior will work very strongly in order to ascertain the free and transparent nature of this election, but more importantly, we all answer to the judiciary now. We all answer to the judges, and the judges in every society are the people who they issue their judgments in order to make sure that society lives in a fair way, and this is why His Highness the Emir decided to give the judges this total power over the elections, to make sure there is no way that any government entity can influence the elections. Not to say that we did influence, but we want to remove any rumor or notion that could happen.
In addition, the Council of Ministers issued a number of bills linking the budgets of a number of state institutions for the fiscal year 2012-2013, which were published in the official Gazette. Although the articles of the Constitution have been suspended twice, the document nonetheless remains the basic statement of intent for the Kuwaiti political system. The Constitution defines Kuwait as a hereditary emirate, the succession of which shall be in the descendants of the late Emir Sheikh Mbarak al-Sabah. Despite the fact that Kuwait's constitution grants the Emir substantial power, it also provides for political participation by the citizens. Individual rights protected by the Constitution are extensive and include personal liberty and equality before the law, freedom to hold beliefs and express opinions, and freedom of the press. The Constitution also grants citizens a number of social rights, which form the basis for Kuwait's extensive welfare system. The state is constitutionally obligated to care for the young and to aid the old and the ill and the disabled. It is obliged to provide public education, to attend to public health.
إننا في الكويت ندعو دائما إلى التخطيط الشامل سبيلا علميا وعمليا لتحقيق التنمية المستدامة وإنجاح مشروعاتها المستهدفة، وإنني أؤكد على أن قضيتنا المركزية في التنمية تقوم على بناء الإنسان باعتباره المكون الأساسي في مواجهة قضاياها. ولا يفوتني أن أنوه بدور شبابنا الواعد في صناعة القد المأمول، فهو حجر الزاوية في أي بناء وإنجاز، وإنني على يقين ثابت بقدرة أبنائنا من شباب الكويت على تلمس السبيل الصحيح، وهو حريص على تجاوز تحديات المستقبل، متوسما أن تعيش الأجيال الكويتية قوية محمية من الصدمات والنوائب، شريكة في المسؤولية الوطنية، عاشقة لبلدها، متصلة بتاريخها وتراثها.
Furthermore, the Constitution provides for state involvement in the national economy to the degree that these obligations necessitate. However, Article 16 through 19 protect private property, stating that private property is inviolable and reminding citizens that inheritance is the right governed by the Islamic Sharia. Article 20 stipulates that the national economy shall be based on social justice. It is founded on fair cooperation between public and private activities. Its aims shall be economic development, increase of productivity, improvement of the standard of living and achievement of prosperity for citizens, all within the limits of the law. Besides the fact that Constitution grants the rights of the Kuwaiti citizens and other organizations and institutes, the Constitution gives the National Assembly the absolute power to draw the legislative policies and control over the executive authority. With such constitution, the state of Kuwait went through some 290 years of democracy, and His Highness the Emir Sheikh Sabah Al Ahmed Al Jaber Al Sabah currently and ever stresses that democracy is the main pillar of Kuwaiti system of government and political action.
وإذ أجدد اليوم التأكيد بأن التزامنا بالنهج الديمقراطي وبالحرية المسؤولة ثابت وراسخ ومتجذر، وهو خيارنا جميعا الذي لا رجعة فيه، فإن الدستور يمثل العقد الذي ارتضيناه حكما عادلا يعمل الجميع تحت سقفه وفي إطاره، وهو الإنجاز الحضاري الذي نفتخر به ونعتز، وسأعمل دوما من أجل صيانته وحمايته. ولا شك بأن الديمقراطية تعني لغة الدستور والقانون والحرية المسؤولة المحكومة بالأطر القانونية المحددة التي تحقق المصلحة الوطنية العليا وتتيح الرقابة والمساءلة والنقد الموضوعي لكل خلل أو تقصير، ولم تكن يوما أداة للفوضى والانفلات والتشكيك والتحريض. فطوبى لكل من عاش من أهلها على ترابها ضارعا مرضاة الله في وطنه، وطوبى للحكومات والمجالس التشريعية المتعاقبة، وطوبى لكل مخلص كان له شرف المشاركة في مسيرة بناء الدولة العصرية، دولة القانون والمؤسسات.
The procession of democracy started in Kuwait over 2 centuries ago. Since the beginning of the Kuwaitis' choice of ruler of Al Sabah family through nomination and allegiance, when Sheikh Sabah I was elected as the first ruler of the state of Kuwait. It is noteworthy that consultation or shura system between the ruler and the citizens is based on the principle of exchange of opinion, amicably, with respect, and without despotism of opinion. Based on these principles and the awareness of the rulers of democracy, of the essence of democracy, the Kuwaiti democracy procession underwent different phases which expanded up to our present day. The vision was clear with the beginning of Kuwait's independence in 1961, which delivered the first Kuwaiti constitution in the Arab Peninsula.